Partners, a hedge fund, real estate fund in New York. There was actually no harm, no damage. The SEC said, you know what? You aided and abetted the unlawful activities of this person because you allowed them to bring you investors and you paid them for these investors. That was unlawful activity. And so they didn't hit them criminally. They hit them, when I say aiding and abetting, they hit them up with civil penalties and fines.
And more to the point, what we're all here gathered to talk about is the City of Miami Regional Center. And you've heard Mickey say she's going to do due diligence on projects, but now you know the level of diligence. Who's going to be marketing this? We need your marketing plan. We need to see, how you're going to be offering this project, how you're going to be structuring the project so that it fits. Because not only is the SEC and FINRA kind of looking at this, and does the investor have a right of rescission potentially, but the center could be shut down. And that could impact all the other investors and all the other projects.
Exactly.
So it's really important, especially with the scrutiny of all of these agencies now, that diligence is done.
Right, and again, you're going to hear about the the no action letter. There's this thing called a finder. What's a finder? Basically a finder who's somebody who's not in the business of raising or engaging in the offer and sale of securities or making introductions. And it just so happens it's a one-off. They have some people that might be interested in investing. You haven't vetted them. And you say, here's my list of people. Here's a Rolodex. And I'm not getting a success fee. You're just going to pay me. What the SEC allowed early on in the 90s, they're not allowing now. They don't like finders. They basically say if you have transaction-based compensation, essentially if you're getting compensated on a success fee basis, they deem to be a broker-dealer. I'm not going to tell you they'll win all the time, but it's very expensive to defend those cases, and I don't think the City of Miami is going to want to be involved in a gray area because it's expensive, it'll impugn the reputation of the regional center, and no one wants to be a pioneer. It would be better to live off of precedent and live within the guidelines of what the SEC is providing in terms of their
How have we been protected in our business plan, in our application against this liability issue that is out there for all privately run regional centers and most government-sponsored regional centers that don't manage it themselves?
Right. So the way this is designed is, think of this regional center as a landlord. They own an office building. And everybody who wants to associate or be a tenant in that office building can submit an application and be vetted. And then they move into the office building and they have to live by the rules of the office building or they're kicked out. So if I had a bad actor in an office building, the landlord, the owner of the building, is not impugned or charged with the activities of the tenant. The tenant is charged. So the way we've structured this is the regional center is going to undertake certain activities, but the way it undertakes these activities does not put it in the chain of unlawful broker-dealer activity or promoting a project that would forget about securities laws, but promoting a project that would otherwise lead to liability for statements made to encourage or induce or entice somebody to make an investment in a particular project that is associated with this regional center.
And also, could we, before we take questions, could we touch upon, Steve, the process that the investor has to go through and how that is totally separate from the City of Miami, whereas they have to file their own applications, they have to go through their own lawyers, they have to be vetted by Homeland Security, which has nothing to do with us.
Well, the investor world is my colleague Laura's realm. I just want to make one. We oftentimes are approached by investors, and Laura's practice is to represent the investors, assist them with obtaining the visa, and evaluating projects from an EB-5 compliant perspective. As a corporate securities lawyer, I review third-party offering documents and do the due diligence to make sure that they're fair, full, and complete. And if I find a document that has omissions of material fact or shows laziness in drafting by failing to put in risk factors that should be there, my recommendation to the client is not one to make an investment or non-investment, but that the documents are deficient, and that should raise a flag.
In terms of investors who are interested in a particular project of the regional center will be advised that they need to get their own counsel their own immigration counsel, and their own financial counsel. So you can't just rely on the documents from the project. You should have a financial advisor look at the diligence that's been done on the project and do their own diligence. If there's a broker-dealer that's affiliated with it, the broker-dealer would have done their diligence. But the investor is not an investor of the City of Miami. It's investing in a project that's been approved or been accepted into the City of Miami Regional Center. They will be expected to do their own diligence and then work with their own immigration counsel on the filing. The filing itself will be done kind of in conjunction with the project. So the project leader, the project that's putting together the PPM and the subscription agreement will work in conjunction with the investor to put the filing together, because it's in both their interests to have that application approved. So the initial investor petition to Homeland Security will go in with a very detailed, what we call I-526 template. It will include the offering documents, the subscription documents, information about the investor, their source of funds, their tracing of funds. That will be submitted to Homeland Security. Right now it's taking between 12 and 14 months for that to be approved. At the end of the 12 to 14 months, the investor will go to the U.S. Embassy or consulate in their home country, get their temporary green card for themselves and their family, under the children under the age of 21, and spouse, come into the United States, and then 2 years from the time they enter in their capacity as a conditional resident, they will file a petition to remove the conditions, again, proving up that the project still is in existence, it's created the jobs, and that they've committed those funds, and those funds were invested in the job-creating entity. And that will be done separate from the City of Miami. Miami will have a reporting requirement. They will make sure that the funds were put into the pooled investment vehicle. They will keep track of how many jobs were created, and they will make reporting requirements to Homeland Security, but they will not opine on the investor applications themselves.
Right. However, we will review through council, because this is what we need SEC counsel. Every offering document that is submitted by an applicant that has been approved for the City of Miami will be thoroughly looked at on our end, because we have to be sure that whatever that project is offering passes muster with us. So it's not that we're going to get involved in telling them how to write it, what colors to use. We're going to make sure that the law is complied with. So they will be at that second layer of review. When I told you that we would go up to the EB5 council and there would be a project-specific review, that's where that's going to happen. No offering documents go out by any project that's been accepted by the City of Miami unless there's been a thorough Securities and Exchange Commission review.
So just look at the chart for a second. There's a yellow box, which is connected to all the other boxes. That yellow box is the pooled investment vehicle that raises the money. That's the LLC of Limited Partnership. That entity raises the money and it loans it to the project company, or makes an investment in the project company that then uses the money to pursue the project. The regional center is off to the left. You see that through an administrative contract. Their real function, again, is by contract to provide certain informational filings on an annual basis for that particular project company. And that's it. That's the function of the regional center. Nothing more. It will go out and market itself to the public as a regional center, so that the public domestically and internationally knows that it exists. And they're free to call the regional center and ask what types of projects are currently associated with that regional center. But that's the relationship. One second. The other areas are again, just a recap of the securities law. That box at the top, the investors, the relationship the investors have with that pooled investment vehicle, the offer and sale of securities, that's the Securities Act of 1933. The yellow box is governed by the Investment Company Act of 1940. To the left, you've got the general partner and the managing member, which is regulated by the Investment Advisors Act of 1940. You have the green box at the top, How do they associate? We're the ones that are coming to the project company or coming to the pooled investment vehicle saying, we have investors for you. Pay us for referrals. Those are the broker dealers you need to be concerned about. Make sure appropriately licensed. And then again, you have the regional center that's associated with the enterprise in order to enable that enterprise to get indirect and induced jobs by contractually agreeing to file certain documentation on behalf of that pooled investment vehicle on an annual basis with the Immigration Service. Question?
Final question, would this be available after the
Hold on a
conference?
minute, let me get you your mic so you can speak and everybody can hear you.
It's not a question, I just wonder if this chart and the business plan will be available after the conference. We can't see the chart.
The chart, it's up to the creator.
Oh, I'm happy to share the chart.
Okay.
Okay, and the business plan, will it be available?
The business plan will be available online, and you can get it online. If you write me an email, remember, I am asking for your cooperation on this. You communicate with me via email. I want to send your request via email, and I will entertain them all, because I want to keep a record of what we're doing, how we're doing it. The business plan is available, but I will make sure you get it. The portions that apply to your question, more than happy to do that.
I have a question. So, since this is the city of Miami, how will the people be appointed on that second level committee? And secondly, will this all be, will all this be subject to the state sunshine and public records laws? No?
Yes, of course.
Oh, okay. And thirdly, even though this law firm has, I understand, been generous in providing free time and effort to get to this point.
No, not free time.
Oh,
A
okay.
lot of effort, but no free time.
Okay. What is their role going to be now?
Their role is as counsel to the regional center.
Okay. Thank you.
Counsel to the regional center. And to Mr. Crespo's question, everything that we do is subject to public records as well as to federal. So we've got the double whammy here. And also, will we provide information? Absolutely.
And the appointment?
¿Cómo?
The appointment. Who appoints these
I
people?
can't hear you, sir.
Who appoints the people?
Oh, yes. It is a project-specific council, sir. The lawyers will always be involved to review the offering documents and all that. If it's a project that has to deal with hotels, we have to get an expert that is an expert in EB5 hotels. If it's a project that involves academic institutions, it has to be it's not an appointed council that is reviewing everything. It's specifically appointed, and it's going to be a volunteer group and not necessarily local. No one that has business with the city of Miami will be appointed to that council. And that's in the applications.
But
because these are academicians, these are people that basically deal with this on a national and global basis. Is there anything else that I need to add?
But will that group be part of a pre-approved list or wheel?
No.
No, just...
No, sir.
Okay.
No. You know, you're always going to get people that are going to say, we'd like to be involved, but it's a volunteer group. So we do expect a lot of university level professors. Definitely council has to be a part of it. And we're going to invite, if we have a project that is very large and that we really feel requires someone looking at it who has done this before, is maybe retired, we will invite those people. But there will not be appointments. The only people that are always standard operating procedure are the interdisciplinary review members who are part of the City of Miami administration. Sir.
I'm trying to see something to simplify a little bit what the role would be of most of us here as a lawyer or as a realtor.
Sure.
We have abroad someone who is interested in purchasing a motel.
I'm sorry, say that again, purchasing a motel?
Purchasing a motel, just any investment that you would like to do.
But that's not what we do. and let's get clarification here. We're not going to be, if you have a person who or a client that wants to buy a motel to run something and he needs money to do that, that's not what we do.
No, that's not, that wasn't.
I'm sorry.
that's not-
Okay, so what is that? Tell me a little bit, expand on your question so we understand it.
Let's say we are either realtors or lawyers here, and we know that there are investors abroad who approach us to say, we would like to make an investment. We have the $1 million, we have $2 million, 500,000, whatever it is, to qualify. At this point, we heard everything that we have to be scared of. So,
Yes.
what I'm saying is, what's the roadmap here? The clients call from abroad and he wants to know from us, what do we do once we heard this? Now
And it's
we're
very,
not talking.
and they're gonna tell you, but the lawyer is the lawyer and the realtor is the realtor. So,
I understand.
and that's what they're going to tell you, the difference between that.
Right, so let me answer that. You have relationships offshore that would like to take an opportunity to seek a visa or get a visa under this program. So you then perform your services as a lawyer, or you perform your services as a real estate broker. You, as a lawyer, you would represent that investor in the review of the securities offering documents, and you would counsel that investor in terms of issues associated with those documents from a legal perspective. You're practicing law, you're getting compensated to practice law for that person. As a real estate agent or broker, if the individual wants to buy a piece of property to do their own deal, build a hotel, renovate a motel, whatever it may be, the real estate broker then would represent that individual in the purchase of that real estate and be compensated for those services. Neither of those services involve getting paid by the developer, by being paid by this person who's looking for the money. They're not paying you for a referral. So you can do everything that you do under your real estate license, everything you do under your attorney, your law license, your legal license, but you just can't be paid for a referral.
And that's what happens with a lot of immigration lawyers. We are approached and asked, where should we invest our money? We're interested in the EB-5, and we have to say, we're not financial advisors. There are a lot of designated regional centers and projects that have been looked at by Homeland Security, and here's a list of them. Where some immigration lawyers get in trouble is they say, oh, I've got these 5 Vietnamese investors and I'm going to put them in this project, and the project's going to pay me $5,000 per. That's an ethical violation, and it's also a broker-dealer violation. So we're seeing some issues with that.
But again, back to the realtor issue, because we get a lot of calls about that. The realtor cannot be compensated for bringing an investor to a project, period.
But he or she can be compensated a fee from the seller of real estate for having represented the buyer in the acquisition of the real estate.
What can we tell the investor about, what can we tell the investor about the project that the city is offering? What is
You can tell the investor anything.
Or what shouldn't we say more than what?
Now remember, they're not giving you individual legal advice, okay? Because I don't want you to rely. What they're telling you is the truth, but
I'm talking as a lawyer, as a realtor as well. How can we present what the city is trying to do? How far we can go?
It's always wonderful, and you can't, see, the key is being paid. You can't be paid for these referrals. That's the dispositive issue. So you're always welcome to let people
Be a
know
friend.
about projects that are available
Be a friend.
that would help them in their visa application process. You're always welcome to do that. That's not a violation. It's being compensated for the referral.
And you know what, I think it might be helpful, we've done at the firm some do's and don'ts in the broker-dealer area and the referral area. What we could do is repurpose that and do something for the city of Miami that you could actually put up on the website, like an FAQ, how this would work, so that we could give you hypotheticals and some, real concrete kind of examples, because I think we may be kind of chasing our tail. But I think that might be helpful if we put something up for you, some FAQs, and we can
My apologies if I didn't make that clear. That usually is the scenario that happens is people want to make referrals for compensation, and it's the compensation issue that really creates the problem.
But simply speaking to the questions that I received, I get a call from ex-realtor who says, I have a client in Mexico who wants to invest, and how much am I going to make off of this? The answer is you can't make anything off of it, because unless you're a registered broker-dealer, not under real estate purposes, but under SEC rules purposes, you don't make money by bringing an investor to a project. That's bottom line,
I'm
right?
going to ask myself a question because, again, we can talk hours on securities laws. You're going to hear things about, oh, there's an issuer exemption. If I have a company and I'm raising money for my company, I'm exempt. I don't need to be a broker-dealer. There are rules you need to comply with. And again, there's federal and state rules, and they're not always consistent. So if you're an issuer and you're raising money, the issuer doesn't need to be registered because it's not affecting a transaction securities for the account of another. It's affecting a transaction and securities for itself. But what about the officers or directors or the general partner or the managing member of an LLC? They are engaging in that activity for the issuer. That's for the account of another. What the SEC did is they clarified the rules because they knew that an entity has to act through personnel. It's fictitious. It can't act by itself. And so what the SEC said is, okay, look, if you're not what we call a bad actor, somebody who's prevented from engaging in securities act transactions, and if you haven't been associated with a broker-dealer in the last 12 months, and you're not being compensated in any way for raising money, we'll let you do it once every 12 months. That's the exemption. So if they're doing it repeatedly, 2, 3, 4 times, that you fall out of what the SEC has given as a safe harbor and you put yourself at risk.
But they have to be working for the project
Or
enterprise.
the entity that's raising the money, so they're the employee of the entity, they're the employee of the general partner or the managing member. It's called the Rule 3841 exemption. Once every 12 months, that's not just for this entity, it's for any offering. Once every 12 months, haven't been associated with broker-dealer in the last 12 months, not a bad actor, no compensation for raising securities. And you have to, once the securities offering is done, you must be engaged in providing substantial duties and other services for the enterprise. So it's not really disguised, I'm just doing it for that period of time to raise money.
Okay, I have a question here.
Yes, sir.
First of all, congratulations and thank you for bringing true job creation to the city of Miami and adjoining counties. The question that concerns not on the security structure, but on the individual investor. Some regional centers say that if you're bringing an investor with $500,000, there's a $50,000 fee. Okay, you're not doing this through this center. Okay, the fee you're going to charge it on top of the
Is the applicant. We don't.
is through the applicant. You're going to deal directly through the applicant.
No.
So-
And no one can get that 50,000 unless they're registered broker-dealers?
So that's a different, that's a whole different concept. When you see the securities offerings, you'll see them for 550,000, 560, 540. 500 is the amount that goes into the investment vehicle for the job creating enterprise. That other component, the 45 to 50, that really goes to the offshore immigration agents that are referring the investors here to the United States. It's kind of their placement fee. And then sometimes a portion of that is allocated to legal counsel to do the work for the immigrant.
But it's the project company that collects the administrative fee.
Correct.
And then allocates that.
Now,
It's not part of the job creation.
Understood. Now, on the fee that is charged by this regional center, will that include the business plan, cost of creating the business plan, and does it include the economic impact study?
The applicant is responsible for the business plan, the economic study, everything.
Well,
We do not charge to write anything, to do anything. We're going to charge an application fee to review it, okay? When the applicant comes to us, they have to come with a very thorough business plan. The economic study, and by the way, I forgot to acknowledge what I believe was one of the most important components of our application, which is Jeff Carr, who is a nationally known economist based in Vermont, who actually did the economic study. And believe me, if we hadn't had that, we might have had a wonderful application, but this is all based on numbers and on jobs. So I wanted to make sure I acknowledged him. Back to your question, Dulio.
So the economic impact study and the cost of the business plan can be part of the reimbursable cost from the 500,000?
No.
No, absolutely not.
500 has to go in the job creating enterprise. The entity that's raising the capital typically also has skin in the game. No EB5 investment with, no, I should say no, there's always exceptions. Typically the EB5 investment doesn't represent more than 50% of the capital stack. They generally want to see at least 25% of the principal's equity in the deal.
After that, skin in the game.
Skin in the game.
Absolutely.
So it's going to come at it. So there's some upfront cost that's the skin in the game. I think what you might be alluding to is oftentimes you'll see regional centers, and regional centers really should be operating the way that the City of Miami Regional Center is operating. But a lot of regional centers decided that they wanted to make more money than just an annual fee or an upfront fee for filing documents with the Immigration Service. And so we see a lot of regional centers now forming pooled investment vehicles to raise money for project companies, and they say, don't worry about it, we'll take care of it for you. We'll do the economic impact report, we'll get the business plan done, we'll raise the money for you, we'll get it for you, we'll charge you 6 or 8%. They pay 3% for the money, they charge you 6%, they make a spread. That's what you see the regional centers doing. There is an inherent problem with that model because of the broker-dealer laws, which is why you're seeing some of the better regional centers and well-known regional centers now having captive broker-dealers to be able to engage in that.
If I could address on the broker-dealer side, a real quick story. As a MC of an event a few years ago, I met Steve, and I listened to him get up and talk about this new thing into EB5, talking about the SEC, and I'm thinking, boy, here the attorneys go again. By the way, I'm not one. I'm just a simple businessman, and a consultant at EB5. And my associate then booked another seminar, and I'm like, oh no, here's the Steve guy again. And so Steve gets up and he's talking, and I'm like, oh my God. We took a break, and I said, Steve, can you calm it down a little? You're scaring everybody to death. Which is including me. And the reason why I'm telling this story is that I took it upon myself to start digging in at that point in time and start to learn. I heard that the USCIS had a visit from the SEC, and the SEC had obtained several hundred files. To me, that meant they're very serious about what they're looking at. At that time, I started to look into what's it going to take to become a broker-dealer. You've probably seen me up here nodding my head at a lot of the things that Steve has said, and the reason why I'm doing that is because I'm currently studying for my license. Okay? And the things that he's saying, I'm like, yeah, I just learned that. And it's like, the environment is changing greatly, and so it is extremely important. You're going to see this is a broker-dealer environment. There's no doubt about it. And one of the challenges that's out there is the broker-dealers understanding EB5 as well. And so I think that's something very important. I just happen to have one of my colleagues here, so if anybody has specific questions, I do have a broker-dealer licensed in the room.
And that's not a solicitation in any way whatsoever. Let's make that clear. Okay.
Okay, we have a question over here.
By the way, one of the reasons I'm so strict is we're fighting an uphill battle because of legacy. And this is a wonderful program. And the only thing that's going to stand in its way are individuals and entities not following the law. I do not want to see this program evolve into something that's incredibly difficult to manage from somebody seeking to either get a visa or access that capital because of abuses. So I may be standing up here pounding a table, but the reason I'm doing that is because if everybody were just to follow the guidance, and it's so easy to follow.
That's it.
It is.
We've been doing it for I've been practicing 25 years. We've been doing it for 25 years. This just has, again, an immigration overlay. It's so easy to follow that you know, why ruin a good thing? Really, it's a wonderful program, and the only thing that's going to ruin it is extra regulation because people are abusing it.
The Public Records Act. I'm not aware, perhaps you've already taken care of this, of any specific exemptions under the state's public records law for documents that would be submitted to your vetting commissions as part of this process. And one of the concerns I would have if I were representing a sponsor of a project was handing over my business plan and my sensitive proprietary information and then having it subject to a public records request by a competitor that would affect, you know, my ability to really generate my project profitably. And my second question is, are you really sure that the Sunshine Act applies to your vetting commissions? Because that seems like that would really require you to file public notices of your meetings, have the meetings again in the sunshine, then the proprietary information might be revealed. So I think from a business perspective, a project sponsor perspective, I think I'd be concerned about those things and I'd want to know that my information was protected.
So we're not turning over any of the business plans of the project companies. Those are the project companies' business plans. Those are handled along with the project company's Securities Council and Immigration Council in terms of filings with the Immigration Service. And those typically are filed in connection with the I-526 petitions that an immigrant files to see if they're eligible for the program. But as a regional center, we are not filing documents on behalf of anyone, other than administrative filings that are statistical numbers on the, the I-924.
Yes. Sorry, that really wasn't, my question was not directed.
It's more the review
My question
process.
is, what goes to the city, what goes to Mickey and her committees, I'm not so concerned about the securities part, but when you guys are doing your vetting, I think you said you need business plans, you need to know who's going to be doing the marketing, how you're going to do the marketing, who's involved. I mean, there's a lot of information about the finances and the plans and how the company is going to make money and profit margins and whatnot. And, you know, usually you don't want your competitors to know that. How are you going to protect it?
Well, the first thing we have to do is make sure we comply with the open sunshine. And so that is we're never going to accept anyone from doing this. It's going to be strictly the way that any project that goes before building and zoning or the planning department, that's all public record. Every project that comes to the city, that comes to the commission, is always public record. And that's the way we're going to continue doing it. If it's a financing plan, you know, basically it has to be a thorough business plan. But again, it's no different than when a developer or when an interested party comes to the city, comes to the planning department, it's the same thing. Everything that is brought before the city becomes public record.
Hi, thank you for holding this meeting. What kind of international marketing or efforts have you put in place or initiatives to promote regional center and vetting projects?
Not as many as we like, because that all takes funding, but we have taken advantage, and that's again something that we said to the federal government. By virtue of being a city, you have all kinds of resources available to you. You have community resources, community groups available to you. What we have done, and again, we have been very prudent in marketing, or the word is not marketing, in letting the world know about our regional center, because we had not been approved. So we were especially careful, and every presentation that was made abroad, whether it was the mayor or whether it was someone who was visiting and mentioned the regional center, was always done with a caveat that, hey, we are not approved yet. The day we get approved, we hit the ground running. But we have, in the past, told people, hey, we're doing this is our application, this is what we're doing. We have a hypothetical, which means that this is the project that everybody involved in the EB5 industry has said, it's a short type of project because you only require, you know, it's an 80% already financed. It's the beautiful marquee project. but we have not done the actual out there sponsoring work, which we are starting to do now. We just went to Spain a few, maybe last month. I went for a few days. I gave presentations on the EB5 projects in terms of not the projects we have, but the actual concept, because they are, if you think you get confused, the world is totally confused. There's just too many brokers out there who are not certified, who are saying, you know, Mr. Investors, come to America, pay me $10,000, and there's a lot of misinformation out there. So it was more of an informational. Once we get our portfolio running, then we can go and sponsor sessions where we will provide the same information.
See, there's nothing wrong with the regional center going to another country, meeting with others and saying, here's our regional center and this is our mission. And oh, by the way, these happen to be projects that are associated with us, feel free to call them. But this is our mission, this is what we're doing as a regional center in terms of looking for projects that would fit within the mission of the city of Miami and the surrounding counties. They're not sponsored or promoting a project, they're promoting their regional center.
But let's be real. If by the time we go, we only have one project, we can't say, invest in this project, but if they say, which is your project? Well, we have one project, but that's what we're trying to avoid. We are really moving forward to get, and again, I don't want to say to you, we're gonna have 20 projects. We don't want that. If it's 20 quality projects that pass the muster that you've heard up here, beautiful. But we're going to go, we want the quality, we don't want quantity. That's the bottom line. Yes, sir.
I'm going to try to be very brief. Very happy to come to this event. Like Russian. I have two questions. First of all, I want to congratulate Ms. Canton, our friend Willie Gord, and the rest of the people from the city of Miami putting together this event. I have two questions. One, I missed, you mentioned before, what will be the cost of the application to join, and when will you start to take application to join? And the second question will be to Steve.
Yes.
Will be more toward the difference between finder fees and placement fees. You just mentioned that these $40,000 to $60,000 administration fees that are the projects allowed to charge usually are used to compensate those people abroad to help them to raise capital. And those fees were called placement kind of thing. But you also mentioned before that the Immigration Services is not happy anymore with what we call finder's fees for actually also non-resident aliens. What will be the difference here? And actually brings me back to the thing. What if a project that wants to join the city of Miami doesn't disclose to the city of Miami that it would be perhaps inclined to compensate those placements there abroad and later on start doing it?
Well, to your first question.
The other one is different.
Okay. To your first question, the fee that we would charge, it's more of an administrative fee. And that is going to be a floating fee because it all depends who the applicant is. If we're talking about a project that's brought, let's say, for an academic institution or an institution that, for the homeless, I'm just giving you examples. The city will be very lenient in those fees because we just want to be accessible. We don't want to say to you, you can't pay, so you can't come to us. If it's a major developer, if it's someone that, is substantial, well, of course, that's going to be treated. And I don't, I'm not trying to be, unfair. I think I'm being very fair. That's the way we want to do it. We want to make this open to everyone. To your question about the actual, that $50,000 that may be paid to some person in Argentina who is certified, or, and by the way, the governments all over the world are being very careful. They're requiring licensing of those people as well. That's not our issue. The city of Miami would have nothing to do with that. I mean, that is between the project developer and who they choose to hire. However, we will be very, very vigilant. And part of their application will tell us if that's what they're willing to do. My chances are that most project developers will want to hire very credible, professional people abroad that are,
And that'll be part of their marketing plan.
and that's their issue. But we will always know. That's going to be always a part of what they have to submit. We will be asking a lot of questions.
I'll answer the securities questions, but one of the benefits also flexibility in terms of application fee, or whether it's paid up front or over time in terms of components, as some projects are more complex than others. And the city is going to be devoting resources. And so when you look at a larger project versus a smaller project, it's just like a real estate commission in a way. If you have to have adjustments so that the city isn't losing money, draining the resources because they're spending a tremendous amount of time and energy vetting something. So I think that's also one of the reasons Mickey is looking at flexibility so that a proper evaluation can be made and a fair and reasonable application fee or processing fee can be charged. So let's talk about offshore and domestic. I'm finishing up the question that he asked about finders and broker-dealers. Anybody who's involved in the offer and sale of securities, the nomenclature is anybody who affects transaction in securities or induces or attempts to induce the purchase and sale of securities is a broker under Section 15 of the, under Section 3 of the Securities Exchange Act of 1934. The question is, can they do the activity and get paid for it? And under Section 15, it's unlawful to engage in that activity if you use the instrumentalities of U.S. commerce. So let's take somebody offshore. There's an immigration agent that's licensed, somebody who's licensed in their particular country to the extent that license is required. They're dealing with the investors offshore. They're talking to the investors offshore. They're marketing offshore. It's okay to do a due diligence inquiry, and it's okay to have a conversation with somebody in the U.S., but their activities are primarily offshore, and the SEC takes a territorial approach. So we as a firm have been comfortable that if all of the activities are taking place offshore, while they are a broker, they're not using the instrumentalities of U.S. commerce in a way that would be frowned upon by the Securities Exchange Commission and state blue sky regulators, state law regulators. When we talk about the distinction between a finder and a broker-dealer, let me make a general statement. If you're involved in the offer and sale of securities and you're getting paid, you're a broker. Now let's figure out whether you're a broker that the SEC is going to come after, or a broker that they're going to say, you know what, you fit within something that we called at one point a finder. What the SEC does is it'll look at the level of activities that you participated in connection with that offer and sale of securities. Were you soliciting investors? Were you negotiating the deal? Were you handling funds? Were you marketing? You know, what were you doing in that process versus simply, hey John, here's a list of people. Don't know if they're interested, but pay me something. Flat fee, regardless of whether they invest. If you have success compensation, and nobody typically pays money unless there's success, you're going to be viewed by the SEC and most state regulators as a broker. And I wouldn't even go down that finder route. If you really want to be a finder, you're going to have to sit down. You're going to have to go in detail with the Securities Council. They're going to have to look at every little fact because it's a fact specific. They're going to give you alternatives and say, this is what's your risk tolerance? And what's good today might not be good tomorrow. And it's vague, so be prepared to spend $500,000 in defense fees or have a public record that you've engaged in unlawful activity and now you're doing a cease and desist. So it's a whole level of analysis. So think of it as you need to have a license, and if you're not going to have a license, it's a very fact-specific analysis.
Yeah, the few EB5s I've done have been direct. So my question is, once these projects have become part of the Miami Regional Center, shouldn't the immigrant be secure that you're going to back him up regarding that part? All he really has to show is the track of his money? I mean, if you're the regional center.
Well, as you know, you've only done direct,
Right.
but under a regional center, you're never guaranteed. This is an investment just like any other, and it doesn't matter whether it's a private EB5, the 500 and something out there, or a public EB5. There's no guarantee. However, what we guarantee is that at our level, we're going to give it the top level of review. That's what you guarantee.
A comfort factor that the regional center has embraced this particular project, because the regional center is going to make sure that they're doing their own diligence on each project, but they're not going to give the investor, they're not going to interact with the investor.
No, I understand, but they're going to give a report to the investor.
No, they're not.
No.
This is what happens. Again, I'll go back to my analogy as a landlord in a building. If you went to an office and you wanted to hire a lawyer in that office or an accountant in that office, just because that lawyer or accountant is at Rockefeller Center or one of these well-known office buildings, you may say they're successful because they're associated, they're a tenant, but you're not going to get a letter from the landlord vouching for the project. So in this particular situation, what is likely going to happen is the following. You're going to have projects that are associated with this regional center. Investors should have the comfort that this regional center, because of oversight, is going to do things properly in terms of reporting and its interaction with the Immigration Service, and that it's not going to abuse its license or designation as a regional center, which may result in a termination of the designation, which would then be disastrous to the immigrants, because there would no longer be the indirect and reduced jobs, that you have a benefit from an active regional center, which then reduces the number of jobs and results in denied I-829 petitions. So that's the comfort. What will happen is a lot of people will be associated with this regional center, and then they're going to go tout in the marketplace, but we're sponsored, or we've been vetted, or we've been approved, or we've been verified by the regional center. That's not going to happen, and that's grounds for termination. Because we, as the representative, I'm a lawyer, right? So my client is going to say, we're going to make a regional center available to you. We're going to do the things that regional centers are going to do, and it's more than one person that's doing it for a for-profit endeavor that might err and take on certain things that might result in a denied or terminated regional center. That's the end of it. Not that we're promoting, not that we're giving an investment representation letter, not that we're vouching for the viability of the project. If the regional center were to do that, it puts itself in the line of exposure. Forget about securities fraud. Simple liability under principal agency, under fraud. It doesn't matter. It's somebody making a representation on behalf of somebody else. Mickey would never let that happen, and that's what I said at the beginning of this session. She put me to task. She said, I want to know more than the securities law implications. I want to know how to protect this institution. And that's the dialogue.
So it's the individual project that gives all the documentation.
Exactly.
Yes. And remember, this is no different. USCIS rules apply to almost 600 regional centers nationwide. So and when we say there's never a free risk, there never is a free. It's just not. That is the way regional centers work, whether privately owned or publicly owned. And that's exactly, to your point, why the SEC has jumped in, and I am so happy, because when I began, looking into this regional center, I said, there's potential for all kinds of stuff happening here. But it doesn't have to happen, because all you have to do is do things right. And, as we're just telling you the worst case scenario, but it's not that difficult, as they said, to put a plan together, because if you submit the right documents, if you do everything right, you shouldn't have any problem, okay?
One last question. that panoramic project, is that ready for investors or not yet?
They have to get it market ready, because remember, it was a hypothetical. Now they have to get their documents ready. They have to get their subscription, their offering documents. They have to go through the same process that anybody else would.
So there's no project yet that's ready for
I would
investors?
hope, because I would hope that we will have it ready as soon as they get it ready. One thing that I want to impress upon you is the regional centers should never, and Steve touched upon it, have to raise the money, 100% of the money a project requires. We would never look at that, because that is crazy. If you're going out to investors and saying, I got this great project in Miami, the first thing a smart investor will say is, how much money is in it already? How much equity is in it already? How much have banks lent? How much has the project owner put into it? You expect me and other investors to put all the money in there? Anything, in our case, even though 50% seems to be the usual, the acceptable, we are going to be very strict on that.
Yep.
We're going to be so strict on that, because if you don't show me, as a developer, as a project person, that you have money already, and you're coming in asking for a percentage, you need a little bit more, you need 20%, you need whatever, we're not going to approve you. Because we don't want a project that relies solely or in the majority on regional center type funds.
It's not marketable, and it's also not smart business to have such an underfunded capital stack. You want to have a traditional capital stack with a component that's EB-5.
And again, most of the major projects that have been built throughout the United States have a portion of their funds raised through EB-5. But if a project requires 70%, 60, even 50 makes me nervous. That's not the kind of project that you want, because, it doesn't get built unless you get all this investor money. That's ridiculous. It's just...
And I thought I'd just make one comment, Laura and I have both been involved and successfully been involved in projects that raise hundreds and hundreds and hundreds of millions of dollars. So we've done this for a while, but we represent some of the largest real estate developers and smallest developers in the country, and we've had tremendous success raising, and as I said, hundreds. We've got probably $2 billion on our desk now. So a lot of insight that you just don't see on the internet, and that you don't pick up until you're involved in a project and there's an issue.
And remember, their role with the city is as our lawyers. So, and I'll let them speak to that. They're not going to be representing developers. In the case of Panorama, they've already done the documents, okay? But their job here is not to double dip. That's not where they make their... Now, if they want to go represent an investor group somewhere else, that's a different story, because that's between them and the project. But our situation, and they can speak to that, is basically there are attorneys in the whole process. Am I right?
We're the attorneys for the region.
Please. So, because I don't want any misconception. You're saying, boy, these guys are going to, really reap the profits. That's not the way it works in the EB-5 world, the way we see it here, the way I see it.
This actually is a perfect segue question-wise. So, having gone through the process with Panorama, and there have been a lot of questions about the business plan, I was hoping that maybe Tom could give some clarity to everybody about what it takes, because having done the application from the business plan side and being part of a large organization that did it, it's not something that you would necessarily want to do on your own because of the complexity and nature of the type of offering that you're creating, where it's almost like would be akin to an IPO. And I think that someone like Tom, who helped us with our business plan, should explain to everybody what it really entails.
That's very good.
Thanks for putting me on the spot there, Dean. I appreciate it. Putting together a business plan, guys. As a business consultant for many years, one of the things that I would always go into and economics and doing things with other companies is that it amazed me when the first thing I walk in the door, I would ask, where's your business plan? And it's right here. Wow, that's great. You're in trouble. Amazing. So one of the things that I've always believed in and would do is to coach everybody to, let's start with the business plan. Let's find the one that you had, let's dust it off, take a look at it, redo it, and figure out what went wrong. The business plan for a business on your operation is one thing. Your business plan for EB5 is totally different. You have to take that business plan, the operational business plan, and then meld it in with the EB5 business plan. And I'll tell you, it is, as Dean knows very well, and everybody, it's a very difficult thing to do. But once it's done, it is a complete and solid roadmap. If it's done correctly, done well, it's got to do two big things. The one thing it has to do is to sell USCIS on the fact that this project is going to work and all those jobs are going to be there. Because this is, let's face it, it's about the jobs. This is not about the money as much as it is about the jobs. Okay? So it has to sell them on it. That's the first step. And that's on the front end with them, and that's on the back end with them when the I-526 comes through, which is when the investor invests their money, and that gets filed. And then they dig in there. So they're going to look at that business plan again. And then the business plan, and having gone to market in Asia several times with my clients, I've been right in front of many different investors and immigration brokers, and that business plan gets really picked apart again. And so it has to sell them on everything that's being done correctly. And with that being said, now that what I know about the SEC side, thanks to Steve opening my eyes, is that it has to address that as well. So the business plan is a very, very critical piece, and we went through a lot to get it done, and thank God for having somebody like you, Dean, to get that done. So
when we submitted the application, since we were using Panorama as a hypothetical, we had to present a business plan, and that's the way everyone's going to do it. To Rocky's question, she's gone. How do you protect your clients' ideas? Well, it's like, as I said, if you come to the city of Miami with a project, it's public, and there's nothing wrong with that. I think that's great. Now, do you in your business plan have to put, stuff that doesn't go in your offering document yet? Well, no, because remember, at the level of review on the first tier, that's the level that you've got to sell us on making sure that you're not only complying with everything, but that this is a good thing for the city of Miami. We don't want to get into trouble by saying, oh yeah, someone told me to take a look at it, and it's not going to happen, folks. It's and I'm sorry, but this is way too important for us at the city. For me, for them, professionally, this is going to work, and this is going to work right. And if people do what they're supposed to do, it's not going to be an issue. It really isn't going to be a problem. It's not that difficult, yes, sir, to put an offering document together.
Yes,
No,
I was wondering, is this like the introductory conference?
Right.
And the next ones are going to be more detailed in specific areas?
Tell you what we're going to do. Today was the first out there kind of thing. We were hoping to make sure that we let everybody know what they can and can't do. Because I think that a lot of people who were hoping they could be involved in the program are not going to be able to be involved because they had a lot of issues on broker-dealers. So this is the first step. The next step will be based on whether we need to deal with individual projects, what your business plan should look like, whether we need to just update you on what's going on with the regulations. That's what we're going to do. It will be announced. The press has done a terrific job of getting the word out. And too terrific, we've had to turn people away not because we don't want them, but it's just limited. You can't put too many people in here. If we need to use a bigger forum next time, we will. I do encourage you to follow closely. If you go under the USCIS website, there is a section specifically for EB5 regional centers. Just get in there, and actually it's very good reading, it's very enjoyable, but it'll give you so much information on all of the topics that our experts have covered today. We may not do a monthly event, you know, there's no point in doing them just for the sake of doing them, but we're definitely going to be doing informational sessions at all levels.
And then, if you go to eb5insights.com, which is a website we sponsor, we post articles daily, if not monthly, on the subject matter, and they're very practical and insightful. eb5insights.com.
What's the?
No hyphen.
Yes.
I just wanted to know, as a broker-dealer, are there currently any registrations or designations that exist? I know on the paper side there aren't, but perhaps on the Homeland Security side or anywhere where I can better market myself as a broker-dealer?
Well, are you a broker-dealer under SEC guidelines?
6763.
I don't know the answer.
All of the designated regional centers are on the USCIS website.
Okay.
So that's a good place to start. And then most of the active regional centers have active websites.
But there's no additional registration or licensing that I can pursue at this point?
Are you private placement?
No, not right now.
Okay, that's needed.
So you'll need a 72, a 79, or an 82, depending on whatever your broker-dealer who's sponsoring you requires. And in terms of marketing yourself, other than going and speaking at seminars and writing articles and having a good website, there is no organization right now that's promoting EB5 investors, and I'm not aware of any additional licensing other than that required by state and federal regulators.
But that's a great thing to start thinking about, like we have organizations.
Already.
You did? There you have it? Yeah, because I think it's great to have a certified, organized
Exactly.
broker-dealer group.
Some type of process or something to verify.
Just like you need to.
CPA or CPA, exactly. Thank you.
I'm glad to be here today. Does Miami's regional center cover all three counties?
Yes.
So you have no partial preference to do the Miami?
Well, our partial preference is always going to be to the city of Miami. We definitely did not want to let the opportunity go by. And we jumped at it. We gave it a try and we got it. We didn't use Monroe County because frankly, it's not anything against Monroe County. I don't want to go on record saying that they're not a great place to invest. I think they are. But we just we didn't want to get into too much. So we have Miami-Dade County, we have Broward County, and we have Palm Beach County. Now that leads to a very important point. If there's a project in Palm Beach County, there's a project in Broward County, that interdisciplinary review committee will, and it's addressed in our business plan, would invite the decision makers, the directors at the levels that, they need to be looked at, planning, the building and zoning. We will never make a decision on what project belongs in another county unless and the same thing for cities, another city in Dade County, unless we feel that interdisciplinary review committee is really well representative of where that project is going to go. And that's part of the plan. So if there's a project in Hialeah, we're going to invite the decision makers at the Hialeah administrative level to vet that. We have to oversee it, but we are not going to tell Hialeah what we want them to build. We're going to let them make a decision.
Does any project within those three counties areas have to go to Miami Regional Center?
Always. If we're the regional center, we have to approve them.
So there's only one regional center approved by the university for the three counties?
No, there are many privately owned regional centers, and I keep on saying, do not confuse us. because they have their own projects, which they themselves have decided that are their projects. But we ourselves we will select the projects based on the rigorous review that we have talked to you about. And though other projects may say Miami in them or Palm Beach in them or anything, those are mostly are privately owned with their own sets of business plans and with their own issues, or good or bad, whatever. Let the investors decide. We don't take any kind of ownership or partnership endorsement, and we will never do that. We will just not do that.
Question for Steve. Under the regulations, when can the investors expect to get their money back? Does it have to be in cash?
I'll let Laura answer that.
The regulations require the money be at risk, and there can be no expectation that they're going to get all of their money back, their principal back, and any kind of contemplation of return on the investment needs to happen after the I-829, the removal of the conditions, is actually approved. If that is not presented in the documents to Homeland Security, the green card will be denied. If the money starts coming back before the I-829 is approved, or if that's in the presentation of the documents that that's going to happen, then it will be denied. So it is a fully at-risk investment, and it needs to stay that way until the 829 is approved.